Welcome into TYT's A Conversation. It is your host, Adrienne Lawrence. Today, I am joined by a voice when it comes to civil rights. She is a civil rights attorney as well as consumer law attorney, and her name is Sheryl Ring. Thank you so much for joining us, Sheryl.
Thank you so much for having me.
Now, Sheryl, I know there has been just legislation sweeping across the country, particularly in red states, that have been attacking members of the trans community, but largely geared toward youth. But it seems there's something different going on in Missouri. Is that right?
Yes, earlier this year, an amendment was proposed as an addition to one of the more, I don't want to say run of the mill because none of these are run of the mill, but news reports, as you said, have been focusing more on the anti-trans youth bills. Missouri included an amendment that would have banned all transition care, all trans affirming medical care through the age of 25. Citing research that says that age 25 is when the brain is fully developed. And it's something that unfortunately other states have picked up on as well. Florida since then has also, as part of Ron DeSantis's recent spat of executive actions, Florida has picked up on that as well. And now there is talk of bans on Medicaid treatments in across red states for trans people aged 25 and younger.
Wow, that's very, very upsetting, particularly because we're not talking about children here. We're talking about banning trans affirming care for adults, people who are 18 and over and can make decisions for themselves or legally should be able to. And seeing something like this come out of Missouri isn't shocking for me, given that they seem to be on the forefront of a lot of backward ideas and mindsets at times. But it seems particularly cruel to deny people access, even if you're citing brain maturity, especially when liquor laws are 21 and older. So yes. What am I missing?
You're not missing anything. The interesting thing is that a lot of these states already have contradictory laws to this effect on the books. So, for example, one of the reactions that we saw to this amendment when it was first proposed was saying, well, if you can drive at 16, you're saying that you can drive at 16 and then another decade before you can transition. You can vote at 18, you can join the military, but you can't take the actions necessary to protect your life and to live as your true self. And part of what makes this so dangerous is it puts trans people in this catch-22. And it's something that is deliberate on the part of transphobes who are passing this legislation. On the one hand, you have people saying that trans people can't be allowed to compete in sports, to use facilities that match our gender identities because we are having gone through natal puberty, we are somehow different than cis people who share our gender identity. So you see that trans women are different than cis women because we went through natal puberty is the example we hear a lot. But then they turn around and deliberately push back farther and farther and farther the age at which trans people can get that affirming care, thereby increasing the very same differences that they claim are so important. And so what this really is it's an eliminationist ideology. It's the idea that we are going to make it so you have no choice but to deal with the very things we're saying make you unfit to be a part of society. It's why bathroom bills are so dangerous for the same reason. Bathroom bills are an example of what used to be called bladder leash laws. Basically, an idea that marginalized groups of people were not allowed to use public restrooms because that way they would be forced to stay within one full bladder of their home. And it's actually part of the legislative history of a lot of Jim Crow laws. And in the 19th century, a lot of misogynistic laws that prevented women from leaving the house and owning property. So what we're basically seeing here is a repeat of that, increasingly targeting trans adults that is intended to make sure that trans adults do not have access to public spaces.
Wow, and so we know that this House Bill 2649 has been introduced and looks like it potentially could go all the way. And that's really scary, especially because we know that the research shows that early gender affirming care and interventions show better outcomes when it comes to transgender and non-binary adults. And I'm sure it does play significantly an impact when it comes to mental health and suicide rates, self-harm, and so on and so forth. So it seems like this could have some significant just negative consequences for individuals who are in Missouri, right?
Oh yes, and it goes back to the same kind of eliminationist ideology that I was talking about before. So, for example, if you are saying that you have to wait until you're age 25, we know that trans teens, especially trans teens who aren't able to get affirming care, have suicide rates that are the highest of any population in the country, and trans teens of color are even higher than that. And so if you're saying we are going to force you to live in a non-affirming environment until you're 25, frankly, a lot of trans kids aren't going to live that long. And the problem is that's the point of the law. They are essentially saying you must either live in a manner that you cannot, you must live in a way that is not your true self, or you can kill yourself. And that is essentially the position that bills like what was introduced in Missouri are placing trans youth in all over the country, especially now that we're talking about putting a ban on Medicaid, gender affirming care through Medicaid for trans people up to the age of 25.
That's absolutely disheartening, and I know that these are going to be dire consequences and that it does need to be stopped. So I guess what can people do, or what are the legal ramifications potentially in terms of intervening should this pass and become law?
Well, one of the difficult things that we saw over the weekend was when a Trump appointee actually blocked a series of executive actions that President Biden had taken to protect trans people under the Civil Rights Act and under Title IX. After the decision in Bostock versus Clayton County from the Supreme Court a few years ago that banned anti-trans discrimination in the workplace, the Biden administration took the next logical step and under the same statutory language, attempted to move to protect trans people in educational facilities. And a Trump appointee just blocked that, saying that in red states, they do not have to adhere to that. And that's the first step we were seeing in the judicial branch to sort of rolling back Bostock to say, well, we didn't actually mean all of what we said when we said that discrimination on the basis of gender identity is discrimination on the basis of sex, as Justice Gorsuch wrote in his decision. And so the problem now is it leaves trans people with very little recourse if the federal government is not allowed to preempt these state laws through power that Congress has expressly granted, even though that is what 50, 60 years of precedent has established Congress has the right to do and the president has the right to do. It leaves trans people in a situation where if you can't rely on the federal government because Trump appointed judges are going to say the federal government cannot preempt contrary state action, you at that point are looking under your own state constitution. You're looking under other statutory provisions that maybe haven't been explored before. Equal protection is one that I know some people have been looking at. But largely the problem is we're living in a strange new world, especially post-Roe, where gender identity is one of those rights that Justice Alito wrote is not deeply rooted in the nation's history and traditions. Justice Alito, as you're aware, rattled off a whole list in Dobbs of rights which are not deeply rooted, and being trans, unfortunately, is one of them. And so the problem is we're sort of in this post-Roe world where we don't know what the courts are going to do when it comes to a right to privacy and bodily autonomy, and we're still trying to figure out how far will the courts go to protect the right to bodily autonomy that until earlier this year was considered as a given. And so since that right technically no longer exists, we're trying to figure out what other ways can we look to protect our bodily autonomy in a post-Roe world.
Yes, and I think that that's something we all need to be invested in. Unfortunately, a lot of people think if it doesn't impact me directly, then I'm not going to use my voice, not fully appreciating that even if you do not care about members of the trans community, it means the rolling back of other privacy rights and rights that are attached to you that you do enjoy. And so I do hope people truly give this some thought and fully understand that their voices need to be used in the now. And so what efforts have you seen at the larger level in terms of organizations, grassroots movements to try to curb some of these efforts?
Well, the first thing that I've noticed and I've been very heartened by is I've been noticing a lot of coordination between trans activism and reproductive rights activism. And partly that's because they go hand in hand. Reproductive rights and bodily autonomy for trans people are two sides of the same coin. But also, there is this myth out there that trans people don't need abortion care. And the reality is nothing could be further from the truth. Trans men and non-binary people also need abortion care. And these laws that are preventing that kind of gender affirming care that trans men and non-binary people need also make it more likely that they are going to need abortions if they're not able to medically transition, or if they're not able to be treated medically in an affirming way. And so one of the things that I've been heartened by is seeing that there has been some coordination on that front. I'd like to see more of it. I think it's really important. But I have been heartened to see that a lot of people have been recognizing these are two sides of the same coin. The other thing that I have been heartened by is a lawsuit in Florida that basically said that there is a religious right to bodily autonomy that the Dobbs decision potentially infringes. I don't know where that is going to go, but as a Jewish person myself, and it's a rabbi bringing this lawsuit, I think that's an important step. If we are going to be saying that a right to religious freedom is the highest and best right, I mean, as the Supreme Court seems to believe, there are a lot of faiths that specifically recognize both a right to bodily autonomy when it comes to being trans, a right to bodily autonomy with respect to abortion, and a right to bodily autonomy with respect to sexual orientation. And so I think that's important to recognize also, that this is not just a one-way street in that regard. And so this is it's a developing situation. I think that we have not seen the last of this. This is going to be fought out in the courts for months and years to come.
Absolutely, it is. And I definitely encourage everyone to very much get involved so that we can stop these efforts and also make the changes and advancements toward progress that we need. And so thank you so much for that enlightening insight. Sheryl, can you please tell the viewers where they can find more of you?
Oh, thank you so much for having me. I am on Twitter at Ring, RING_Sheryl. You can also visit me online, www.SherylRingLaw.com with an S, not a C.
Thanks so much.
Thank you for having me.